Get ready for the dictation. Start. On facts, once the principal legislature expressed its intent otherwise by enforcing those provisions with effect from 1/4/2021, the situation in law arises otherwise. The pre-existing provisions no longer continue to exist. No amount of effort by the delegate could resurrect those provisions or infuse life into those dead letters of law in absence of enabling law delegating such function to the delegate of the parliament, that is to the central government or any other authority. Adopting the submissions advanced by Sri Agrawal and Sri Chopra and Sri Anubhav Mehrotra, learned counsel for the petitioner, has laid stress on the fact by virtue of sections 4 and 6 read with section 292 of the Act, both substantive and procedural provisions under that Act remain dynamic, since the Act seeks material validation every year through enactment of the Finance Act. Income tax laws suffer a process of continuous change, and there is no inherent logic or principle embedded in that law to save a pre-existing provision despite enactment of another law in the subsequent year. Such changes are suffered both by substantive law as also procedural law. Relying on the above, he vehemently urged the provisions of the Enabling Act together with the notifications issued thereunder must be seen as they confronted the Act as amended by the Finance Act 2021 on the date of issuance of the impugned reassessment notices. Upon enforcement of the Finance Act 2021, the entire situation and dynamics of statutory law underwent a change. While the Enabling Act did not undergo any statutory amendment or change upon enactment of the Finance Act, the latter Act substituted the provisions of sections 147, 148, 149, 150 and 151 of the Act with effect from 1/4/2021. Therefore, the Enabling Act became wholly unenforceable or incapable to the proceedings that would now arise under those provisions after 1/4/2021. Sri Mehrotra has then referred to certain provisions under Chapter 2 of the Enabling Act to contend even under that Act different dates had been specified for different provisions introduced to the Act. We have already taken note of such changes in the earlier part of this order. Referring to those it has been submitted, there is nothing in the Enabling Act, and in fact there could never be any provision in that Act as may have put in abeyance the provisions of the Finance Act 2021 that was yet to be born/enacted. Inasmuch as the Enabling Act has not undergone any amendment as may put in abeyance provisions of sections 2 to 88 of the Finance Act 2021, and there is no other law to that effect, those provisions continue to be the only law occupying the field with effect from 1/4/2021. All notifications issued with reference to the pre-existing laws would therefore remain confined to the time limits to conclude pending proceedings beyond the date 31/3/2021. Those notifications may never be read to enable the executive authorities to initiate any fresh proceedings under the pre-existing laws which proceedings did not exist on 1/4/2021. Third, it is his submission while enacting the Finance Act 2021, the Parliament was aware of the ground realities. The Parliament was also aware of the existing statutory laws, both under the Act as amended by the Finance Act 2020, as also the Ordinance and the Enabling Act and notifications issued thereunder. Still, it chose to enforce the new scheme for reassessment with effect from 1/4/2021 without enacting a saving clause. Thereby, it brought an end to the possibility of any fresh proceeding being initiated under the pre-existing unamended reassessment provisions after the date 1/4/2021. Stop.